So you've heard of the Hedley Byrne Principle and you understand it. If you don't understand it, watch this video. And you've heard of voluntary assumption of responsibility. You know that it is one of the requirements of the Hedley Byrne Principle. And you know that in this video, I explained that the House of Lords determined that Heller and Partners had not voluntarily assumed responsibility because they had used a disclaimer when they provided information to Hedley Byrne. But does the use of a disclaimer automatically mean that the defendant absolves responsibility towards the claimant? In other words, if a defendant puts in place a disclaimer when they provide information to the claimant, does it always mean that the court will say, oh, you have not voluntarily assumed responsibility, hence no special relationship has been developed and there is no duty of care owed? And what if the defendant does not even know of the claimant when they provide the information? Can the court still determine, or will the court still determine, that they have voluntarily assumed responsibility toward the claimant? And finally, how exactly does the law even determine if one has voluntarily assumed responsibility towards another party? Hi, I'm Denise and you're watching Law with Denise. In this video, I will answer those 3 questions for you. So our first one will be, how does the court even determine if a defendant has voluntarily assumed responsibility towards another? And secondly, what if the defendant did not even know of the existence of a claimant? Will the court, or can the court still say that the defendant assumed responsibility towards the claimant? And finally, we'll answer this question. Does the use of a disclaimer automatically mean that the defendant has absolved their responsibility towards the claimant? In other words, does the use of a disclaimer mean that the defendant has not voluntarily assumed responsibility towards the claimant? Let's begin. Now, in order to understand our first question, I thought we would look at Lord Reid's judgment. Lord Reid was one of the lords who was present in reaching a decision in Hedley Byrne and Heller in 1964. Lord Reid said that when asked for information, we can choose to do one of the following 3 things. Firstly, we can not give the information or advice. Or we could give the advice but say to the other party, don't rely on this. Or you could take the third option, and that third option, according to Lord Reid, is you could give the information or advice but not say, don't rely on this. Now, according to Lord Reid, if a party decides to take the third option, that is, give the advice and don't say, don't rely on this, then they have voluntarily assumed responsibility towards the other party. Let's have a look at a piece of case law to help us see how this plays out in reality. Let's have a look at Dean and Allen and Watts. In this case, Mr. Dean was the claimant and the defendant was a solicitor who was employed by Allen and Watts. How did Mr. Dean and the solicitor at Allen and Watts find themselves in this case? Well, Mr. Dean actually was not the solicitor's client, which is quite interesting. Mr. Dean was being asked to provide loans to a Mr. Beasley and Mrs. Young. Now, these 2 individuals wanted to invest in property, but they didn't have the funds to do so. And they wanted Mr. Dean to provide the funds for them, but on a loan basis. Now, Mr. Dean wanted to have these loans secured. The solicitor at Allen and Watts told Mr. Dean that in order to have these loans secured, the only thing that needed to be done was to have the deeds of the property that Mr. Beasley and Mrs. Young wanted to invest in deposited at the solicitor's firm, so at Allen and Watts. Now, this was appealing to Mr. Dean because this meant that the loan would be secured, which meant that if Mrs. Young and Mr. Beasley could not pay back the money, he would have rights over this property. In the end, Mr. Dean actually gave out loans of a total of £50,000. And unfortunately, at some point, Mr. Young and Mrs. Beasley could not actually pay him back. But Mr. Dean thought, well, it's okay, I've got the deeds, right? So he was holding on to the deeds because that meant he had rights over the property, according to what he was told by the solicitor at Allen and Watts. However, a third party, the party who actually owned the property, because Mr. Young and Mrs. Beasley didn't own the property, they were trying to invest in it with Mr. Dean's money. Now, the third party who actually owned the property said to Mr. Dean, you need to return these deeds because you don't have legal rights over them. Were they correct? Yes, they were correct. What the solicitor at Allen and Watts told Mr. Dean was actually wrong information. In order to have the loan secured, it wasn't just a matter of leaving the deeds at the solicitor's firm. It turns out that there needed to have been a signed agreement and the deeds needed to have been deposited at land registry. None of that had taken place. Therefore, the loans were not actually secured. Mr. Dean then decided to take out a case against the solicitor at Allen and Watts. The Court of Appeal determined that, yes, the solicitor at Allen and Watts had voluntarily assumed responsibility towards Mr. Dean, even though Mr. Dean was not his client. Why? Well, remember, we pointed out that there are three options, according to Lord Reid, that one can take when asked for information. The Court of Appeal said because the solicitor at Allen and Watts took the third option, that is, he provided the information to Mr. Dean, but he did not say, don't rely on this, and he did not say, go and seek other legal advice. He had voluntarily assumed responsibility towards Mr. Dean, who wasn't even his client. Now let's have a look at her second question. What if the defendant did not even know that the claimant existed when they gave the information or advice? Can it still be said that they voluntarily assumed responsibility towards the claimant? To explore that question, we're looking at the case Goodwill and British Pregnancy Advisory Service. In this case, we had a Miss Goodwill who was a claimant. Now, Miss Goodwill was unknown to the British Pregnancy Advisory Service when they gave out a specific piece of advice which became an issue later on in this case. The advice that they gave out was actually given to another party, someone that Miss Goodwill became involved in later on. So she had a relationship with this person and became pregnant by this man. Why did Miss Goodwill take a case against the British Pregnancy Advisory Service? Well, it turns out that the person that she became pregnant by had received information from the British Pregnancy Advisory Service years before he met her, information which told him that after performing a vasectomy, he would not be able to impregnate anyone in future. So when he met Miss Goodwill, at some point he gave her this information, but it turns out it was not exactly accurate because she became pregnant. Miss Goodwill therefore sued the British Advisory Service. Now, what did the court say? The court said that the British Advisory Service had not voluntarily assumed responsibility towards her because when the information was given out, it was not likely that she would rely on this information, and she was not even part of a known group that could have relied on the information. She was simply part of a large ascertainable group that the man in question could have had relationships with in future. Now, lastly, does the use of a disclaimer automatically mean that the defendant absolves responsibility towards the claimant? We saw that in Hedley Byrne and Heller. The disclaimer that Heller and partners put forward was sufficient for them to negate responsibility towards the claimant. However, case law which have followed indicate that if a defendant puts in place a disclaimer, the courts will not automatically say that they have absolved responsibility towards the claimant. The courts will look at the facts of the case, and what they're looking for is to determine if it is reasonable or if it was reasonable for the claimant to have relied on that disclaimer. Now, if the court is convinced that the disclaimer in question was reasonable or it was reasonable enough for the claimant to have relied on the disclaimer in question, then the disclaimer may suffice. But if the facts of the case indicate otherwise, the courts may decide that the disclaimer is not effective. Now, if we look at two cases, we'll be able to see when the disclaimer was said to be effective. The first of those cases is Omega Trust Co. Limited and Wright and Son and Pepper. And we also have McLula and Lane Fox and Partner Limited. In the first case, the disclaimer was with regard to commercial properties. And in the second case, the disclaimer was with regard to highly valuable properties. In these two cases, the court accepted that the disclaimers had been sufficient for the defendant to have negated responsibility towards the claimant. However, when we look at another case, Smith and Eric Bush, we see that the court was unwilling to accept that the disclaimer was effective. In this case, the disclaimer was with regard to the purchase of an ordinary family home, and the courts were not convinced that it was reasonable for the claimants to have relied on the disclaimer put forward by the surveyor in this case. Therefore, that disclaimer was not enough to have absolved the defendant of his responsibility towards the claimant. So I hope this was all useful. Until next time, thank you, and please remember to like, share, and subscribe. Bye-bye.